Well, the Constitutional Court, on the other hand, has upheld a High Court order declaring parts of the Divorce Act unconstitutional. The Act prevents a woman married out of community of property without accrual to claim from their spouse if they get divorced. The declaration of invalidity is rather suspended for 24 months in order to enable Parliament to correct the law. So let's get some reaction now from the acting CEO of the Commission for Gender Equality, Dennis Matotoka, joining me live right here on eNCA. Dennis, thank you so much for your time. Your reaction to this ruling?
No, thank you so much. From the Commission for Gender Equality, we welcome the decision by the Constitutional Court. We believe that the decision is just, it's fair, and it's really acknowledging the plight that women experience, especially in marriages out of community of property with an accrual system. Primarily because we understand that there are non-financial contributions that are generally and most effective not recognized when there is a dissolution of a marriage. So you have a spouse who has a less bargaining power in a marriage, indirectly contributing to the growth of the estate of their partner, and it grows monumentally so. But upon divorce, because there's an accrual system that is applicable, they walk away with nothing. And we believe that is an injustice. And what this court does, or rather this judgment does, it reaffirms the equality of women in marriages, but most importantly, it puts those protective mechanisms that are required to make sure that just and equitable distribution of estates is realized in such marriages.
With also that being said, and the ruling being welcomed from your side, Dennis, do you still expect a pushback? Do you still expect, some camps perhaps thinking that this would be unfair?
Look, once the decision of this nature is made, it's made by the highest court. So we are expected, South Africans, to comply with that. What is needed at this point is that educational programs need to roll out. We have a public education department, amongst others, wherein we will now take the message down to the ground to educate and sensitize people around this new development that is there. But in addition to that, we will really be closely monitoring the process with Parliament to make sure that the necessary constitutional defect that has been pointed out by the Constitutional Court is attended to within the period that the court has pronounced.
In your view, do you think the ruling vindicates more so women than men? Were women the ones, in your view, previously disadvantaged?
Right. So if you look at it firstly from an international point of view, we have instruments that tell us that women in marriages, they have a less bargaining power because they enter marriages while being poor, and that there are different social dimensions that are there and applicable before a person enters into a marriage. And historically in South Africa, we know that women have been prejudiced. They have been excluded. They've been, because of patriarchy, they've been reduced to status of minor historically. So when they enter into marriages, they don't have an equal bargaining power. It's unlike when you are dealing with a commercial transaction. This is about a matrimonial agreement, and we are saying as the Commission, we must acknowledge those different social dimensions that are applicable, and that as a result, it results in women being prejudiced because of those social dimensions. So what we see is that women in the main have been prejudiced because of their childcare roles that they are playing and the domestic roles broadly that they are playing. But those roles are often not even rewarded or acknowledged upon dissolution of a marriage. And we believe that, therefore, it is just of this decision to realize that there are non-financial contributions, which, as the Commission was saying, they ought to be put in the same weight as financial contributions. And what this court does, it does exactly that, and we welcome it as the Commission.
Yeah, because we definitely have heard even, from different activists, perhaps even feminists alike, saying domestic work is work, staying at home, contributing to the household, taking care of the children, cleaning, making sure that everything domestically is well taken care of, is equally work. And I suppose, Dennis, it goes back to the point that you're saying, to say women have been previously prejudiced if they were in those social standings, but now the court observed them as those who've equally contributed to the successes of their partner.
Absolutely. And just apart even from that, which is quite important. But if you look at how they are able to maintain the growth and the growth of the other parties' estates, they look after, for example, if you have a property business, some of them, they're looking after these properties, and the estate, they grow tremendously so. But when now it's coming for divorce, they get absolutely nothing because the matrimonial property system that is applicable there does not allow them to claim. And as I say, we believe that is unjust. But the critical role, of course, the domestic role that they are playing, we cannot put more emphasis on that. Quite important, quite critical. It needs to be acknowledged. And for the longest time, from 1984, it was not the case. And we deem this judgment as a historical one because now it reverses those decisions that were made in the past based on patriarchal attitudes or understanding of what the role of a woman is and what they should be equated to, and subsequently saying that they are not supposed to be rewarded for such. And we really do think that this judgment is progressive and it will go a long way to reaffirm the equality of women in this country.
And I thank you for speaking to me about this. Dennis Matotoka, Commission for Gender Equality's Acting CEO, thank you so much for your time right here on eNCA.